Hello everyone, myself Rituraj, founder and publisher of Burney's Law Journal, and today we have a special guest, Mr. Faisal Sherwani sir. He is partner at Luthra and Luthra. Uh, Today we are organizing this workshop in collaboration with Dr. B.R. Ambedkar Law College, Nagpur. So I request Darshana ma'am to say something.
Good afternoon, all the attendees of today's webinar on the history and nature of criminal remedies under copyright law. I, Darshana Malani, on behalf of RTMNU's Dr. Baba Saheb Ambedkar College of Law, Nagpur, warmly welcome Mr. Faisal Sherwani to this educational meet organized by the very efficient team of Burnish Law Journal. Mr. Sherwani is currently a partner at Luthra and Luthra Delhi and is also an advocate on record in the Honorable Supreme Court of India. We are extremely fortunate to have you among us to guide our students with your valuable experiences in the field and to make them aware of the various intricacies of the copyright law in the country. The room is all yours, sir.
Thank you very much, Ritu, Ms. Malani. Appreciate the introduction. I'm very honored to be speaking with you all today, and I would like to thank you for making this virtual session a reality. So, when I initially spoke to Rituraj first, he insisted that I speak on the subject of intellectual property laws. So in my capacity as a dispute resolution lawyer, I suggested that I'd speak on the topic of the history and nature of criminal remedies under copyright law. Ritu Raj was quick to sensitize me that very many of the audience today, my friends in the audience today, are from first year and second year law school. And therefore, possibly I would be doing greater service to you if I concentrated a bit on the rudiments of the law also. So I think that's not particularly a bad idea. I've always enjoyed working with law students, and it takes me back to my law school days. And it is a reminder to all of us lawyers who sometimes take the rudiments of the law for granted that ultimately we all are students of the law. So in this session, what I intend to do is then give you a little bit of a crash course, the kind of course that the lazy ones look forward to the night before an exam as to what a copyright is and what it grants. I will then concentrate quickly on what are the related rights and the neighboring rights. I'll concentrate a little bit on the limitations and exceptions to a copyright. I'll talk about what an infringement of a copyright is. And I will also talk about then the remedies pursuant to infringement, which are both civil and criminal in nature. And then in the context of criminal remedies, I'll talk about the history. I'll talk about whether it is indeed necessary to have criminal sanctions to enforce copyright. And I will try and treat you in the context of the 2012 amendments to the Copyright Act to an illuminating exchange which I had with a colleague while I was debating whether the right to receive royalties, so to speak, as can be found in section 18 and 19 today, are punishable under section 63. So I'll start from that. It's quite a bit to cover in the limited time that we have, but I'll try and do justice to the issue. So what is a copyright? First, not what it what it means, but what it is at its very core. A copyright is nothing but a statutory or a legal means of protecting an author's work. And the object of a copyright law is to encourage authors, composers, artists, and designers to create original works by rewarding them, by granting them the exclusive right for a limited period to exploit these works for monetary gain. You would have very little incentive to create something which is of some creative value if others could slavishly copy what you have. And that is what the law seeks to protect. So statutory definitions aside for a moment, at its very core, copyright is the right to copy or reproduce, that you will have the exclusive right to copy and make a reproduction of your work and exploit it in the public domain for the public at large. And statutorily speaking, since the law of copyright is codified in India by virtue of the Copyright Act of 1957, Section 14 will give you some sense of what it extends to. A copyright grants the exclusive right to do or authorize others to do acts in relation to what? Literary, dramatic, musical, and artistic works, to a cinematograph film, as well as to a sound recording. And since this is codified in some sense, permit me to say that you will find Section 14 of the Act to be a repository of what a copyright is and extends to, and it extends to nothing else beyond what the statutory provision provides. So, in the context of literary, dramatic, musical, and artistic works, cinematograph films, and sound recordings, the exclusive right which extends is that of reproduction, performance, translation, communication of these works to the public. So, and this extends not only to the whole of the work, but even to substantial parts. You cannot slavishly copy, let's say, a part of something which is protected by copyright. That is equally an infringement. So, copyright is a kind of an intellectual property right, and this has gained greater importance in recent times. Uh, because of the rapid growth in technological developments. You will see that once you have the gadgets and gizmos which made reproduction and copying easy, the world faced a challenge as to protecting rights and protecting the rights of authors and copyright holders. Then, what apart from a copyright does the Act provide for? There are certain related rights in the Copyright Act. One of those related rights is you'll find in Section 37. It deals with broadcasting organizations, the right of the broadcasting organization to reproduce what it has. Equally, then in Section 38, you find a performer's right. There is also a right in 38A, which is the right of author's moral right, so to speak. So apart from these four rights, until 2012, and I'll get to 2012 shortly, these were really the only rights which the copyright, and this was the only, these were the only four rights which it protected against some sort of infringement, both by way of a civil remedy as well as a criminal remedy. And one of the limitations, of course, of copyright is that it does not extend into an abyss. There is always a limitation which is attached to it. In the context of copyright, it is the life of the author plus 60 years. When you talk of a broadcast reproduction right, it is for a period of 25 years. When you talk of a performer's right under Section 38, it is for a period of 50 years. Now, whenever you have a right which is a valuable right such as these, you will have the right to exploit it. And when you will have the right to exploit it, you will necessarily have the right to seek returns out of it. And this can be in the form of a license fee, it can be in the form of a royalty. And nomenclature is not particularly decisive. Then when we talk of limitations, you'll get, from an idea from what I said, one of the clearest limitations is the fact that it extends to a particular period of time, 60 years in the case of copyright, not beyond that. So that's one of the limitations. Then when you talk about exceptions, in order to balance this right, the right of the copyright holder and the right of the user, there are certain rights which by statute have been deemed to be fair use, which even if you were to use without the permission of the copyright holder or the owner, it would not amount to infringement per se. And one of those is, of course, non-profit or educational purpose use. And this is, of course, not for commercial use. Then you have private use, including research, criticism and review, reporting of current events, and any other compatible fair use, such as a parody. If you've seen the movie Meet the Spartans, which is a spin off of the movie which was 300, or 50 Shades Black, which is a spin off on 50 Shades of Grey, you'll have an understanding that a comical sort of a version of an original version is something which falls outside the scope of protection of the Copyright Act. You can make a comical version of a protected right. That's considered to be fair use. Now I'll come to the concept of infringement and its consequent remedies. And infringement is really contained in Section 51 of the Copyright Act. So when you look at Section 51 of the Copyright Act, at its very core, infringement is basically the use or production of any copyrighted material without the consent or license of the owner or the copyright holder. That's the sum and substance of infringement. And what you leave sometimes obscure and what is not particularly clear when you talk about copyright infringement is that you know that a slavish copy is certainly an infringement. If you slavishly copy something who has created a piece of work, that obviously is within the four walls of an infringement, but qua whom? And you will do yourself a great favor if you will look at the issue of infringement from the perspective of the owner of copyright. Truly speaking, it is only the owner who has a right to proceed, in a case of infringement. It attaches to the concept of locus in civil law. And the best way of understanding intellectual property and the concept of infringement is if you understand what real property is and what it grants you. So if you have a piece of land or a parcel of land, typically it will be the owner of that parcel of land or somebody acting on his behalf who will be able to sue or bring an action for trespass. In a similar sense, if you do not have title to a copyright, you will have I mean, there's scant little that you will be able to do when it comes to infringement. And this attains a little bit of importance in the context of the 2012 amendments to the Copyright Act, because what was sought to be granted by the 2012 amendments was a right to receive royalties in favor of authors, let's say in cinematograph films, and somebody who draws a portrait. They, typically speaking, because of Section 17, are not the holders of copyright. So when you give them a share of the royalties, the question which has started to arise today in recent trends is, do they have a right or do they have basis rather to sue for infringement or to bring a criminal action for its infringement of their copyright? The problem is, if you look at it from the perspective of Section 17 and Section 51, if they are not the owners of copyright, strictly speaking, they should not be able to bring a suit against, let's say, the owner of copyright himself. But I'll come to that in greater detail in a bit. So in the context of civil remedies, you'll see that Section 55 provides for some civil remedies, and the most typical of orders that you can seek is an injunction, restraining a person who is slavishly copying your copyrighted material or making copies of your movies. You can seek a direction restraining him from continuing in his ill endeavors. You can also get in direction for impounding and disposition of infringing articles, basically that those articles can be seized and destroyed. And just like any other civil action, you can seek damages, which are essentially compensatory in nature, and which will give you basically put you in the same position you had been if the person had not been, infringing your works. So your loss of business, if you are able to demonstrate it, that may also be compensable. That brings us to the issue of criminal remedies. Uh, and when you talk of criminal remedies, really the provision which is of interest here, the charging provision, is Section 63 of the Copyright Act. And I would encourage you all to maybe Google the provision on your devices if you don't have the Bare Act, for the simple reason that I'll be reverting to the provision on quite a few occasions. So Section 63 talks about offense of infringement of copyright or other rights conferred by this act, right? So any person who knowingly infringes or abets the infringement of a copyright in a work or any other right conferred by this act shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 3 years. Right. So one is clear that you're talking about a copyright, and if you were to infringe somebody's copyright, it could land you in jail, uh, either for a period of 6 months, which may extend to 3 years. So when you talk about criminal law remedies and Section 63, the issue of, let's say, a slavish copy is not so much of a problem because the mens rea is clear. But what about other cases where it is not particularly clear? And let's say it's for purposes of clarity, let us debate for a moment whether you really need to have a criminal consequence for infringement of copyright. History will tell you that it was not always necessary. I mean, if you look at the first Copyright Act of 1847, it did not provide for a criminal remedy for infringement at all. And thereafter, you have the Statute of 1914, where uh, infringement is actually made, it is ultimately made, there is a criminal remedy which is provided, but it extends to a period of 1 year. So, what happened in 1984 thereafter? I mean, the Copyright Act came into effect in 1957, but in 1957, they were not particularly concentrating on the issue of piracy. So, in 1984, what becomes of particular interest is that there are certain technological changes. And those technological changes is of course the video tape recorder. I mean, the first video cassette recorder dates back to 1953, but it becomes widely used in the 1980s and the 1990s. And around this point of time, there is a whole industry which is indulging in piracy. And it's this systematic reproduction of, of movies which is making a dent into the financial returns of Bollywood in India, but film industries across the world. So it was a reminder of our shared humanity and our common problems. So in that context, that was the first time. I mean, if you look at the legislative debates in 1957, there was a sole voice, and that was Dr. D.C. Sharma in the Lok Sabha. He was a legislator, and he did say that the Act of 1957, it did not sufficiently redress the issue of piracy. And I'll quote a bit of what he said. He said that the most difficult problem in this country is not the problem of copyright or the problem of infringement of copyright, but the problem of piracy. Piracy is going on a large scale in India, and I'm not sure if the act actually takes this into account. And then, if you were to talk to industry experts, they would say that the Act of 1957 just did not make sufficient provision for somebody who would slavishly copy a movie, because you would have the video cassette recorder, and I'm sure all of you in law school,
हाँ वो बहुत गंदा था इसलिए मैं वहीं रख दी उसको
somebody was talking over me anyway. So the point I was making was that then you have the technology which was torrents, and those who had access to Wi-Fi would be downloading movies. This became a systematic industry, right? And therefore, a penal provision which would send the perpetrator, who would make a slavish copy or who would download movies not from the original content provider, he could only be penalized, to the extent of a year in prison. And this posed certain problems. This was not sufficient redressal, and that was the sentiment in the industry. So the 1984 amendments basically, really for the first time, sought to look into this issue of piracy. And the statement of objects and reasons to the 1984 amendment are particularly clear on this. I mean, not to say that the text isn't, they were dealing with piracy. And the statement of objects and reasons in part say piracy has become a global problem due to the rapid advances in technology, It is assumed alarming proportions all over the world, and all of the countries are trying to meet the challenge by taking stringent legislative and enforcement measures. So, what did they do by way of the 1984 amendments? In particular, what they did was they extended the period uh, which you could serve in jail or in prison if you were convicted of an offense of copyright infringement. Yeah, where it was initially a punishment which would extend for a period of 1 year, it became a penal provision as the statute now reads, which may not be less than 6 months, but which may extend to 3 years. So when you look at this penal provision now, it started a whole debate, and this debate has not been resolved yet as to whether Section 63 provides for a cognizable offense or an offense which is cognizable in nature or which is non-cognizable in nature. And since we have first year and second year law students as part of the audience today, I'll tell you a little bit about what a cognizable offense is. You won't find any reference to what a cognizable offense is in the Copyright Act. It doesn't deal with the classification of offenses. For that, you go to the Code of Criminal Procedure, and Section 2C defines a cognizable offense as an offense for which a police officer may, in accordance with the first schedule of the code or under any other law, arrest without a warrant. And a non-cognizable offense is one where a police officer has no authority to arrest without a warrant. So, in this context, uh, it it assumes a little bit of importance because often a recourse, let's say, a lodging of an FIR, is something which is typically done by business competitors. And if a police officer can arrest you without a warrant, and if an offense is cognizable, then you want to know that it is cognizable and that the police can take notice of that. What is typically cognizable? If you look at the first schedule of the Code of Criminal Procedure, the offenses in the IPC are broadly classified. If they are, punishable by 3 years or more, you will see that they are. You'll find that they are cognizable. But when you talk about offenses which are prescribed in laws other than the code of other than the IPC, you will find in the context of the, for example, the Copyright Act, where the offense here is in section 63. There you look at the second part of the first schedule of the Code of Criminal Procedure, and it says that if an offense is punishable by 3 years or more, the offense is, if it is punishable by 3 years or more, it is treated to be cognizable. The result of that is that a police officer can launch an investigation into an issue on the receipt of a complaint. He can lodge an FIR, and he also has the consequent power of arresting you under Section 41 of the Code of Criminal Procedure. Now, the difficulty why it launched a debate into the issue is that while the Code of Criminal Procedure indicates that an offense which is punishable by 3 years or more, that is what is treated to be cognizable. In Section 63, the language which is used is that it may extend to 3 years, and the obvious sort of difficulty in interpreting that is that when you say it may extend to 3 years, it may not extend to 3 years also. Typically, not typically, but genuinely speaking, sentencing is one of the last things in a criminal trial. It is when the guilt has been clearly determined. The last stage is sentencing, and there are various factors which weigh in the mind of a judge as to whether he is to sentence you for 3 years or less than 3 years. So, in that context, many people will argue that it is unfair that a police officer should be able to launch an investigation without a warrant, and also that it's unfair that he should be able to arrest you without issuance of a warrant. And why the issuance of a warrant? Because a warrant requires application of a judicial mind. A magistrate is the one who will issue a warrant. He will look into the facts of the case, and only when he is satisfied that an offense is made out, will he grant a warrant for, let's say, investigation? And therefore, the problem is that, today these provisions are used typically to harass a business competitor. And the difficulty is that, I mean, you'd be somewhat innocent to assume that your average policeman is, beyond reproach. He can, of course, be, convinced to launch an investigation at the request, let's say, of a private party against another private party. And therefore, you want to have certain protections before the police wholesale, launches an investigation. So that's part of the debate, and some high courts have taken the view that it is cognizable for the simple reason that, on conviction and ultimate sentencing, on an application of judicial discretion, the punishment may very well extend to a period of 3 years. And some high courts, such as Delhi and Andhra Pradesh, for example, have taken the view that the offense is non-cognizable for the simple reason that while you may be punished, let's say, for a period of 3 years, it is very likely that you may not be. If you ask my personal opinion on it, since we are conscious of the legislative debates in 1984, and we are conscious of the reason why Section 63 was made to extend to a period of 3 years, let's say in a case of infringement, we are conscious of the fact that they were dealing with privacy. So piracy. And piracy is something, let's say, you would not be able to find a clear line of defense. You can be, you should be able to be summarily convicted for it also, because I don't think you will ever be able to make out a case that, I by mistake made a copy of a movie, and by mistake I sold it in the market for a commercial gain. So the mens rea, the criminal intent behind that sort of an act is clear, and it's a systematic industry. You are able to make several copies and distribute them commercially in a sophisticated manner, and that is something which, if you were to punish the individual or the organization for, let's say, a period of 3 years, or the officers of that organization for a period of 3 years in jail, you might have some sympathy for that sort of an adjudication. But there are more difficult cases also, and we'll come to that now when we talk about the 2012 amendments. So in 1984, as you have seen, uh, they have basically tried, the legislature, the parliament has tried to make provision for dealing with the problem of piracy. And they have extended the penal provision to extend, I mean, the penalty under Section 63 to extend to a period of 3 years. So that is left to judicial discretion. The issue has not been finally adjudicated, in the sense that the Supreme Court, the apex court, has not looked at this issue. Maybe it should. If any of you have an interest in the jurisdiction and exercise of its jurisdictional powers by the Supreme Court, you will see that one of the reasons for invoking the jurisdiction of the Supreme Court and why the Supreme Court should look at an issue, is that different high courts have taken different views. So if some high courts feel that the offense is cognizable and that the police officer should be at liberty to launch a wholesale investigation and question people and issue, let's say, a notice to, let's say, look into documents, then, and some high courts feel that it is non-cognizable, that he should not be able to do so, then that is an aspect that maybe the Supreme Court should look at. So then the more difficult sort of cases that I was talking about, you will see that these have arisen consequent to the amendments in 2012. So the Copyright Amendment Act of 2012 sought to bring a new sort of right, which was otherwise not there in the statute. Prior to the 2012 amendments, like I had mentioned, in the Copyright Act, there were basically four rights. The copyright itself, which you will find in Section 14, the broadcast reproduction right, which you will find in Section 37, the performer's right in Section 38, and the moral right of the author, or the performer's special right, which you will find in Section 38A and Section 57. Apart from this, there were no other rights in the Copyright Act which were directly protected, and to my mind, protected at all. There were no other rights which were thought capable of infringement, and therefore thought capable of, a civil remedy either under Section 55 or a criminal recourse under Section 63. But all this while, and this is where I'll direct your attention to Section 17, when you talk of a cinematograph film, for example, you will see by virtue of Section 17 that the first owner of the copyright in a cinematograph film, such as a movie, is the producer. That is legislatively provided by the legislature, the Union Parliament. Uh, Equally in the case of a photograph, equally in the case of a portrait, the person who commissions the work is the first owner of the copyright. The title of the copyright vests in that individual. Generally speaking, copyright vests in the author, and that is what Section 17 also says, except by way of a proviso. And a proviso is a device in interpretation of statutes which carves out an exception. So, the exception in the context of a cinematograph film is that it is the producer. Why? The logic behind that is it is the producer who's putting in a lot of money into the making of a movie, and there are consequent parts of the movie. There is an actor such as a Shah Rukh Khan. There is a person who will write the lyrics. There is a person who will write the dialogues, and all of these, in some sense, are capable of protection by under the Copyright Act. So everybody, if they were to start claiming, copyright in this, in the work that they have done, the producer's endeavor and the money that he has put into, say, the making of the movie, he might not have so much of an incentive to make a great movie thereafter. And it was on that basis that the legislature decided that when you talk of a cinematograph film, we'll leave the copyright with the producer of the movie. But there were certain problems and vices with that decision. I mean, ultimately, when you look at the decision which which the parliament takes, uh, it might or might not be the right decision in your mind. From a moral standpoint, it created a certain amount of economic disbalance in the sense that the persons who would write the lyrics, or the persons who would these are artistic people ultimately, the authors of the lyrics and the music composers, many people thought that they got a raw deal, in the sense that they would not have a right to royalties. I mean, unless they contractually agreed, and you can contractually agree for anything under the Indian Contract Act as long as it is not an illegality. So, but generally speaking, they were thought as not having the same amount of bargaining power. The producer was the almighty person who would have, the money and the decision. And if you didn't want to write, lyrics for a song in his movie, then maybe he would move on to somebody else. So, typically speaking, in the industry, what was the trend was that the authors and composers, of lyrics and songwriters, they would assign all of their rights to the owner, the producer of the movie, by for a lump sum payment. Basically, that is how it used to happen. That they would give you 5 lakh rupees or 10 lakh rupees for writing the lyrics in one go, and that would be the end of your financial participation in the deal. So in those circumstances, even if your song did very well, the songwriter's song did very well, the music composer uh, who would also be involved in that, he would ultimately not end up making a lot of money, but the film producer would be making a big windfall gain, and this was at least felt. And this is not something which should come as a shock to any of you. It's widely debated today in the Indian film industry, and there are factions both ways. So, by way of the 2012 amendments, in that context, what the legislature sought to do, the Union Parliament sought to do, was to give these people, the lyricists and the music composers, equal share, a right to have an equal share in the royalties. Uh, but what sort of royalties? In the context when not when the movie is played within the four walls of a cinema hall, But when your song is played, let's say in a restaurant or in a dining area, today even aggregator cabs, if you use Ola and Uber, Ola typically I think has Ola Play. There you can listen to songs. So when a song is exploited in that sense commercially, this lyricist and the composer would also have a right and right to have an equal share in the royalties or the returns, which let's say the producer in the capacity of the assignee of the copyright would have because of the exploitation of the work. This is what was granted by the 2012 amendments, and that right in that context, what they basically said was this is an inalienable right, that even if the composer or the lyricist wanted to wish it away contractually or to agree that he will not receive, let's say, a return in the form of royalties, he would not be permitted to do that. The Copyright Act today, after the amendments in 2012, clearly says that that sort of an agreement is void ab initio. So this is not something which is unheard of. If you look at the Indian Contract Act, it classifies certain types of contracts as void or voidable. So this sort of an arrangement where the music composer or the lyricist were to agree that I don't want any further royalties, and the music and the movie producer can keep all of the royalties for himself. This is now considered to be something which is not permissible. So it's a common minimum guarantee which is granted to these lyricists and composers, in the sense that this is something which they will certainly have, and it cannot be contractually taken away. And that sort of a guarantee is provided in section 18 and 19. If you read them, word by word, that is basically the crux of what will come out of that legislative mandate. And it was done why? Because they were thought that they did not have the same amount of negotiating power or bargaining power as the movie producers, and therefore, even if you could be persuaded, so to speak, to wish away your right to receive a royalty, you would not be permitted to do so by way of these amendments. But what has started because of that right is a whole debate now, that can an author, in the sense of a lyricist or a composer who is writing the lyrics for, let's say, a song in a movie, a big banner movie made by a big banner producer, can he bring a suit for infringement against that movie producer for non-payment of royalties? Because now, by virtue of section 18 and 19, he is entitled to have a fair share or an equal share in the royalties. So the question that has started being debated in certain forums, and there are cases which are pending. I'm not at liberty to discuss those cases because they are sub judice. But the debate is, can a suit for infringement in a context such as that be maintainable? And indeed, in the context, let's say, of an offense, a criminal offense such as section 63, can that sort of, let's say, can you bring a criminal action against the producer? And you remember when I told you about section 17, that section 17, because of section 17, the copyright vests in the movie producer, the cinematograph film, the producer of the film. So he is the owner of the copyright. But interestingly, there have been instances where, let's say, a lyricist has now brought a criminal action against the producer, and he is saying that you have not given me the royalties which I was due, which is basically the 50 rupees out of the 100 rupees that you have received. So can that be punished under section 63 is the new debate. And everything which I will tell you now, apart from everything else which I've already said, this part of the discussion you can treat as not being gospel truth, because it has not been finally adjudicated, and there are strong views both ways. Some of these issues have been debated in courts of law. I will not really go into the arguments which have been addressed in court, because I'm not really at liberty to discuss those. But what I intend to do otherwise so as to give you a flavor of what that debate is an illuminating exchange which I have had with one of my associates at LNL Partners, and he has basically during the past few days provided a sort of a argument in favor of the fact that a film producer can very well be punished under Section 63, and I'll tell you a little bit about how I have tried to rebut him. But before I start going into that, we can look at Section 63 again, and you can see Clause A seeks to provide for a penal consequence for infringement of copyright in a work, and Clause B of Section 63 seeks to provide for a consequence for punishment of any other right conferred by the Act. So the argument is that obviously when you infringe a copyright in a work, you can be punished under Section 63. But what are these other rights which Section 63 in Clause B talks about? Those other rights are the very rights which we discussed initially, which are synonymous to or at least akin to or related to a copyright. They are often referred to as related or neighboring rights, and that is the performer's right or the broadcaster's right. Now, since a new right was inserted in Section 18 and 19 in 2012, the question is, can you also have a movie producer punished under Section 63 Clause B, because the right to receive royalty is also another right which the Act now provides. So the way I intend to give you a flavor of the debate is, like I said, the one that I've had with my colleague. It's a rather illuminating exchange. I'll refer to him as Mr. Disagree, because that's what he was doing throughout this discussion. So in the first instance, Mr. Disagree makes the sort of an interpretational argument. He looks at Section 14 of the Act, and when he looks at Section 14 of the Act, he says that the right to receive royalty is really nothing else but a subset of the of copyright. So when you look at Section 14, it defines what is the meaning of a copyright. It speaks of meaning of copyright, and it says copyright means the exclusive right, subject to the provisions of this Act, to do or authorize the doing of any of the following acts in respect of a work. So not only to do, but authorize others to do. So the argument that he makes is that basically the person who is the lyricist, he has authorized the film producer to use the copyright. And I have sought to rebut him in this argument by saying that Section 14 has to be read along with Section 17. So while Section 14 talks about authorizing, somebody else to make use of a copyright, you might recall when you look at Section 17 Clause B that the lyricist never had the copyright in the first place. By virtue of Section 17, the copyright vests in the film producer. So there's no question of him being able to assign or authorizing the film producer to make use of the copyright or to exploit the copyrighted material. And this will give you a flavor of how lawyers disagree with each other and take pot shots at each other. The next argument which he makes, which Mr. Disagree makes, is basically he looks at Section 63, and when he looks at Section 63, he says that, boss, you don't know what you're talking about, because when you look at Section 63, it's a penal provision, and the penal provision is to be typically interpreted strictly in a strict fashion. The statute is what it is, and you are not permitted to wish away a certain right, because the language which is used is that what is punishable is any other right conferred by this Act, and the right to receive royalty is one of those rights, and you are nobody to say that the right to royalty is not covered. So while that might appear to be sort of an interesting argument at first blush, the doctrine of strict interpretation of criminal statutes has generally speaking been applied in order to limit the scope of a statute, not to expand it. I'll give you an example. uh, a criminal statute is to be strictly interpreted in the context where, if there is some amount of ambiguity in the statute as to whether a right or a certain penalty is included or not, an interpretation which favors the defendant, or let's say the accused, that is to be favored. And you can't say that, just because it says, because the language of the statute is that any other right conferred by this act, it would include every other right which you can dream of. Because where two interpretations are possible or capable, where I say that royalty is not a subset of copyright, it is a consequence of it. And that's not much different from having a consequence of any valuable right. Any valuable right which you may have, let's say a parcel of land or a vehicle, if you lease it out, you will have the right to receive returns for it. You can call that a lease rental, you can call it a royalty, you can call it remuneration. The point is that you receive monetary compensation in return for somebody making use of your property. And copyright is no different from that. So royalty, which is the right or the remuneration which you have received, that is not something which is tantamount to copyright. It's not something which is akin to copyright. It is merely a consequence of it. There is also an associated doctrine to the doctrine of strict interpretation of statutes, and that is the rule of lenity. And you can read about this at quite some length in the context of interpretation of statutes. And that is that, a punitive statute should be sufficiently clear. One of the principles is that a criminal statute which seeks to impose a penalty in the form of a fine, or let's say in the form of a jail sentence, it should be reasonably clear, and it should give the private actor notice that he can be penalized for acting in a manner which is contrary. I don't get that sort of an indication from section 63 or section 18 or 19. If you look at section 18 or 19, they provide a common minimum contractual guarantee that you cannot wish away your right to royalty. But in a case where you don't receive your royalty, will you be able to send the film producer to jail? That is not something which clearly flows out of 18 and 19. In any case, section 18 and 19 talk about assignment of copyright. It's in the context of where the copyright or the ownership is being transferred to somebody else. So once you have transferred your ownership, it's not clear how you should be able to penalize somebody merely because you have not received royalties. And the concept of fair notice in Anglo-American jurisprudence, a related concept is mens rea, that the criminal intent should be clear. But the rule of lenity goes somewhat further to that, and it was typically applied in English law as well as in early American jurisprudence, in the context where on humanitarian grounds, because capital punishments were handed out quite liberally in early England. Even for chopping down a cherry tree, you could get the death penalty. So in those contexts, while that may be a possibility under the penal statute, the rule of lenity was applied to say that, look, you can't send somebody to the gallows merely because he chopped down a cherry tree, particularly when the statute did not clearly outlaw that sort of an activity. So the next argument which Mr. Disagree makes, and this is one of his favorites, he says, ignorance of law is no defense. So for you to say that I don't know that section 63 also penalizes, let's say, non-payment of royalty to an author after he has a right under section 18 and 19 to receive royalties in equal sum, you cannot plead your ignorance in that regard as being a defense. But section 63 does not clearly outlaw that at all. And while that maxim, ignorance of law, which is it's taught quite liberally in law schools, it's freely taught in law schools, it necessarily implies that it has to be ignorance of a clear and unambiguous law. If there is room for disagreement, or if there is room for two interpretations, you can't say that I'm ignorant. I am not ignorant. I'm merely disagreeing with your interpretation. And in fact, the fact that a penal provision is capable of two differing interpretations, that is also a ground for quashing of, let's say, an FIR or a criminal investigation. Quashing means basically putting criminal proceedings at naught by way of a petition before the higher courts. So that is also one of the remedies. If you feel that an FIR has been registered against you without basis. Then there's a related maxim which is not as freely taught, and this is how I try to rebut him also. Apart from, that ignorance of law is no defense, there is a related maxim, and this is a related principle rather of interpretation of statutes, and that is that the inability of a reasonable accused person or a reasonable defendant to know that his actions are criminal. I'm not able to figure out whether my actions are criminal or whether it might amount to a penalty. Now, if that is the position, it sort of undermines the justice of inferring a criminal intent in some cases. And that is something, I mean, if I look at section 63 and I say that clause A punishes infringement of copyright, and clause B for at least till 2010 to 12 penalized infringement of a performer's right or a broadcaster's right. Today, all of a sudden, if there is a new right and it has not been judicially determined as to whether it falls within the ambit of section 63, I cannot be penalized for it. That's the argument in rebuttal. Then the last sort of argument which he made was, when you look at section 63, you are making an error by thinking that Parliament was not conscious of clause B, and that Parliament was not conscious that, let's say, the right to receive royalties in equal sum, a violation of that right would invite penalties under section 63. And when they made those amendments in 2012, they would have been reasonably conscious that section 63 would provide penal consequences also. The answer to that is that when the amendments in 2012 were made to section 18 and 19, section 63 was left entirely untouched. And therefore, it is somewhat unreasonable to assume that just because they were making some sort of an amendment to section 18 and 19, they would have been logically conscious of the consequences of section 63. While I understand that the broad sort of a presumption is that when the legislature acts, it acts consciously, and it should be given credit of knowing the surrounding provisions and the surrounding circumstances, and you cannot take it lightly that they were not conscious of a particular provision, that to a penal provision which is of the nature of section 63. But the fact of the matter, and this is there is another school of thought on this which has just started to develop, if you have a taste for statutory interpretation. And this school of thought says that this principle that the legislature is always conscious of everything and the whole act and every single provision and all circumstances is giving the legislators a little too much credit. They often work in environments and scenarios where they are not in a position to look at all of the provisions in a statute. And therefore, to give them that sort of credit may be unfair. That's one of those arguments, and one of the instances which is used by one of the writers on statutory interpretation is that of a senator in the United States. While a bill was being debated in the House in Congress, he had taken down the number and the name of some woman that he found interesting or attractive. Her name was Ruth Seymour, and he wrote down her name with her phone number. And out of inadvertence, that lady's name and phone number became part of the first print which was circulated in Parliament for further debate. So that is an indication of how the legislators are not always conscious, and they are not always looking at all of the provisions, that they are often working in haphazard scenarios and haphazard surroundings. And therefore, to give them this sort of a systematic, this sort of basis that they're always systematically aware of all of the provisions in a statute and they're sitting in a quiet corner and reading, is probably giving them a lot more credence than what may be due. Ultimately, many of your legislators you will see are not trained in law. Many of them are lawyers. Most of them are not. They don't really, they're not trained in interpretation of statutes. And therefore, to give them that sort of a credence that they will know what will be the consequence if you insert a new right, that it may or may not be punishable under 63, might be giving them a little too much credit. The last sort of an argument which my colleague made was that, you look at labor laws, you look at the industrial disputes act, you look at the factories act. Many of these statutes, and this he used only as an example, there are a lot of other statutes which seek to penalize any violation of any of the provisions of the act, and they are often punishable with a jail sentence or a term in jail. So the the most obvious retort to that is that it's not permissible when you're trying to interpret what the Copyright Act is and what it penalizes. You can't really look at labor legislation or any other legislation, because the clearest sort of uh, way, I mean, the principle which applies here is that it is permissible to look at other statutes if they are in pari materia, if they have been made on more or less the same subject to deal with more or less the same circumstances. Labor legislations make provision for punishment of violations and contraventions in the context of workers who obviously have even less bargaining power than your lyricists in the film industry. And the recent coronavirus might have sensitized you that many of these poor fellows did not even get to go home, and when they turned up at the railway stations, they were initially asked to pay for their tickets to travel to their home states. So when you're dealing with that sort of a worker or that sort of a laborer, it's obviously reasonable to assume that he would require all of the assistance and protection of the legislature, and that is why uh, every little violation against the little man, so to speak, is made punishable under labor laws. That may or may not necessarily be true for a lyricist who has a lot more bargaining power as compared to a migrant laborer. The last sort of an argument which he made was that he looked at a bunch of dictionaries, and after looking at those dictionaries, he looked at uh, the definition of infringement, and he said that, infringement, at least in one of the dictionaries, also meant a violation or a contravention. Now that argument stems why? Because the argument which I made was that section 63 uses the expression, the first line of section 63 says, what does it make punishable? Knowingly infringing or abetting the infringement of a copyright. The expression used is not contravention or violation. The expression used is infringement, and infringement in the context of the Copyright Act has a circumscribed meaning, and that is you can infringe only a copyright or a performer's right or a broadcaster's right, and no other right. And a contravention or a violation is much broader. So he looked at a dictionary and he said that one of the synonyms for infringement is also violation or contravention. And while you might be able to find a dictionary which says so, mind you, most of the dictionaries did not say that. But even if you were to manage to find a dictionary which synonymously uses these expressions, it is not permissible to look at a dictionary to interpret an expression in section 63 of the Copyright Act. You are supposed to gather the meaning and intent of infringement from the Copyright Act itself, and it is used in the context of a copyright, a performer's right, or a broadcaster's right. It is certainly not used in the context of a royalty or the right of royalty. And therefore, when you look at a dictionary, which is an extraneous source of or an extraneous aid to interpretation, you are trying to expand the scope of the expression, and that is something which is not permissible. Most celebrated authors on interpretation of statutes will tell you that. So that is basically the broad debate, and that's basically what I wanted to talk to you about. I'm sort of glad that I've been able to finish within an hour's time. So if any of you have any questions, or if you want to play Mr. Disagree with me, I'll be happy to oblige now. Hi, are we all still there?
If anybody have questions, please ask your questions.
I think the explanation was so nice that the students don't have any questions right now.
Or maybe vice versa.
No, I'm sure they were, they really enjoyed the session. So there's no question at the moment. But if I do get any questions, I'll be sure to forward it to you.
If anybody has any questions, I'm an easy person to find. You can drop me your questions on LinkedIn or you can mail me. If any of you are interested in any of the judgments on whether the offense is cognizable or not, I'll be happy to have somebody from my office email those precedents to anybody who's interested on further readings. It's a pleasure talking to you all, and thank you for being a patient audience.
So there's a question
Hello.
from a student, Ayushi. She has asked that should we conclude that the artist cannot claim their rights against the producer?
That's a very good question, and I don't have an answer for that. I have a point of view, and that point of view is that typically speaking, if you were to ask my opinion, I don't think that a suit for infringement or an action under Section 63 for infringement would be maintainable at the behest of an artist against a producer of a cinematograph film, because the right of royalty is not something which is capable of infringement in the context that it is understood in the Copyright Act. But don't treat this as gospel truth for the simple reason that seasoned lawyers are debating it in various forums today. This is something which has not been finally adjudicated, and ultimately my opinion might be rejected today but may be accepted tomorrow or vice versa. So I don't claim to have the complete truth on this, but I have a point of view, and it's subject to final outcome before a authoritative forum. That's where we are today.
Hello.
If anyone have any questions, can ask. So can there be application of rule of adjustment? A question from Anusri Sirkhande. Can there be application of rule of adjustment generis?
Yeah, so that's a great question,
Hello.
Anushri. Yeah, can you hear me?
Yes, sir.
Yeah. So that's a great question, Anushri. And when I was debating this with my colleagues, at least one of them did say that we should be able to apply the rule of justum generis. And the rule of justum generis basically is words in association with other words are to take color or meaning or content from the words in which they find themselves in association with. Basically, birds of a feather flock together. So the argument there is that the other rights in clause B of section 63 are sort of synonymous with or akin to or related. They have to be something akin to a copyright. And that's a reasonably good argument to make. It shows that Anushri has a fair understanding of interpretation of statutes, which is paid quite amount of time understanding statutory principles of interpretation. And I think I agree with that point of view. I think clause A seeks to punish infringement of a copyright. And I think clause B, when it says any other rights, it is typically concerned with those associated or related rights which we initially spoke about, which are the broadcaster's right or a performer's right. which are related to a copyright or flow out of a copyright, and they are protected by a certain term under the Copyright Act. So the copyright, the protection is the life of the author plus 60 years. A broadcaster's right is a period of 25 years. A performer's right is 50 years. And those other rights which they're talking about in clause B are those two rights which also take color from copyright. So that's my point of view also, which I mean, I shared the view with Anushri.
Yes, thank you, sir.
There's another question by one of our students. He says, why aren't the apps like Telegram not yet banned, even though it is clear that such apps support piracy?
I mean, that's a very good question from a policy perspective. So you might come across, and I have not used Telegram, by the way. I'm probably not as technologically equipped as some of you, but I've not used it. But I'm conscious that there are a number of apps today which, if you look at them carefully enough, you will come to the conclusion that they are facilitating or providing a platform or a basis for piracy. Why are they not outlawed? The question is, has somebody brought an action in order to bring that activity in question? And there are all sorts of illegalities today in the world. Telegram may be an example of it. But what about the torrents which they used when I was in law school? I mean, I understand it's slightly obsolete technology now, but you could use a torrent to download a movie, a pirated version of a movie. And there was some amount of adjudication at one point of time, which said that it was indeed illegal, but they were never really able to ultimately stop it. Is the reason is that it's very difficult to locate where the servers are and who is running these applications. So it becomes more a question of enforcement. But in the context of Telegram, I'm not conscious if somebody has brought an action to have an adjudication on the aspect of infringement or piracy per se. Maybe that is something you can think about as law students. Maybe you can find some sort of an action to that extent. Of course, you are not the aggrieved party, and it goes back to what we were talking about. Infringement typically is understood in the context of who the owner. So if Telegram is providing pirated versions of, let's say, movies or songs, it is for the copyright holder to bring an action against it. And if they haven't done it, then they've been sleeping over their rights. I hope that answers your question.
Okay, he says it does. Thank you. There's another question. If an IPR infringement happens on a social media platform which is protected by the safe harbor provision, what are the remedies available?
So let's say you have infringing content on a social media platform. Section 79 of provides somewhat of a limited protection to the intermediary, and the intermediary is basically the host or the person who's providing the platform. He otherwise has no particular control over the content which is being put on the platform. For example, you've put on, let's say, some pirated video on Facebook or Instagram, then the safe harbor provision will basically just protect Instagram or Facebook, basically the provider of the platform, from liability. There are certain actions which he will have to take once it is brought to his notice. I mean, obviously, he should not have mens rea. He should not be providing the content. He should not be exercising control over the content, because then he ceases to be an intermediary. But if his platform has been used for projecting it, he is protected to that extent, as long as he quickly removes the infringing material from his platform. That still does not take away the basis or the right of the copyright holder or the owner of the copyright to bring an action for infringement against the person who had uploaded that infringing content on, let's say, Instagram or Facebook. So in that context, the copyright holder or the owner can bring an action either under 63 for putting up infringing material on the intermediaries platform. So the ultimate perpetrator who has put up the material is the person who is clearly still punishable by section 63, as well as by way of a civil suit under section 55. So those remedies will always be there with the person who feels aggrieved by an infringement of his copyrighted material.
Is there any more questions?
Okay, there's another question. Is there any exceptions to the copyright infringement, or if it's permissible in certain circumstances?
So the exceptions and limitations to copyright, when you talk about limitations, limitation is a broader sort of a concept than an exception. The first limitation which will come to mind is that it's limited by way of period of time. It's life plus 60 years of the author. But when you talk about exceptions, you can look at section 52 of the Copyright Act, and what it seeks to protect is fair use. So when you use copyrighted material for your own private or personal use, or for the purposes of criticism or review, at least when you are not making, let's say, a commercial, or you are reporting current events and current affairs. And I talked about parodies. If you make a movie or a spin-off of a popular movie, let's say Meet the Spartans. I don't know how many of you have watched it. It's a spin-off of the original movie, which is 300. Then that is something which, even though you may be doing without the consent or the license of the holder of the copyright, it will fall outside the domain of the protection of the Copyright Act. And typically a suit against you will not be maintainable for that nature of use. Equally, for the same reasons, I don't see you being convicted under section 63 of the Copyright Act. But those are the limited exceptions, and that is so that there is a balance which is struck between the desires and the needs and the wants of the copyright holder, as well as the use of the people in the public domain, or the people in the public. They should have access to these materials as long as the use which they are making falls within the circumscribed limits of section 52 of the Copyright Act.
I think that's about it. Rituraj, you can take it over. I think Rituraj is not there in the webinar right
Yes,
now.
I'm here.
He's back.
Okay. Yeah.
Oh, actually, network issue.
No, I see.
So there is no any more questions. Is there any fixed percentage or quantity which we can use for sharing knowledge?
Fixed percentage in what context? I'm not particularly clear about the question. Could you clarify that a little bit?
There are questions from you too, but they didn't mention some clear questions.
So can you repeat the question?
Yeah. So, is there any fixed percentage or quantity which we can use for sharing knowledge for copying and writer's material?
Okay, so I sort of understand that. There's no fixed percentage, and I think you're talking about in the context of fair use. When you're talking about using a copyrighted material, and you're talking about the exceptions in section 52, where you use a copyrighted material without the consent of the author, you can broadly use most of what is there or substantially what is there. There's no fixed formula because the Copyright Act and its provisions are susceptible to formulaic sort of interpretation that is more the domain of mathematicians. So there's no particular extent, but there has to be, even if you talk of a parody, why is it permissible? You are making a comical sort of a version of somebody else's movie. So there is a certain amount of creativity which attaches even to the parody. You take a movie and you make a comic version of it. So there is some amount of creativity and originality in it. So it should not be a complete slavish copy. Now, this is something which is not circumscribed by way of formula or percentage. It's more a test which you will look at and when you will compare the supposedly infringing copy with the original copy. But let's say if you talk about original works, if you talk about works in the context of educational purposes, for educational purposes, you can make a copy and a reproduction in entirety. Allow me to say even 100%, but you should not make a commercial gain out of it. It should be for your own academic purposes, for your own study purposes, for your private use. You should not be selling copies of it in the law school. Then it ceases to be. And there's a little bit of debate about this also because there was a Delhi University case which Justice Bamani, when he was a senior advocate, he had argued for the DU students. But if it is for the purposes of your own education, for your own research, then it can be a complete slavish copy, but you shouldn't be making a commercial gain out of it. So no percentage, but so somewhat of a comprehensive qualitative assessment would be the test. Do we have any other questions?
Okay, I request our student, Ms. Ronak Katre, to give a formal vote of thanks to you, sir.
Thank you, ma'am. Good afternoon, everyone. Uh, to our honorable and respected speaker of the day, Mr. Faisal Sherwani, our principal sir, and all our respected teachers. This is Ronak Katre giving the vote of thanks on behalf of Dr. Babasaheb Ambedkar College of has enlightened us. I extend my thanks to Burnished Law Journal for taking this initiative, and most importantly, the founder, Mr. Ritu Raj, and coordinator, Mr. Sundaram Bharti. A big thank you for everyone's efforts towards this informative session in the mid of corona pandemic. It illuminated the areas of the copyrights for all the students and helped those who seek the future in it. It was a privilege and honor for us to have every one of you over here. And I extend my thanks once again to Mr. Faisal Sherwani, who has taken his very busy time for enlightening all of us. Thank you.
Thank you very much.
Thank you, everyone. Thanks for joining us. Thank you, sir, for giving your time. Thanks to Dr. B.R. Ambedkar Law College, Darshana ma'am, and our viewers. Thanks a lot. Have a great day.
Thank you very much, everybody.